Please be seated. We'll hear argument in case number 240543, Family Dollar Stores of Texas against JLMH Investments.
May it please the court, Mr. Downey will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Chief Justice Blacklock and Associate Justices, may it please the court. We're here today because the Second Court of Appeals, I think, got two very serious questions of law wrong, and I think that one of those is an easy question to answer. Do you actually have to, as a plaintiff, prove a viable cause of action to get a legal remedy or an equitable remedy in the state of Texas? I think the answer to that is yes. The second question is a little more difficult. If you're required to prove a cause of action and an affirmative defense has defeated your cause of action, can you still obtain the relief of injunctive relief? I think that if you look through the lens of the Schneider National Carriers versus Bates case, and you look through the lens of Crosstex versus Gardner, you reach the decision, the answer, and the answer is no. The injunctive relief claim perishes along with the monetary damages claims when a defense litigant proves that the statute of limitations has, A, applies, B, that the claim accrued more than 2 years prior to filing, and 3, that the plaintiff waited an inordinate amount of time to bring the cause of action to the court.
Before we get too far into the merits, can you help me with appellate jurisdiction? Because there were 2 orders in this case granting motions for summary judgment, and the second order contains layman language, disposes of all parties and claims, and final and appealable. But then there was an order from the trial court clarifying the summary judgment orders and granting permission to appeal and staying further proceedings. And then after that, the plaintiffs just filed their notice of appeal. They didn't perfect a permissive appeal. So is this an interlocutory appeal? Is it an appeal from a final judgment? Or what is this?
Well, this is an appeal from a final judgment. This is one of, I was going to talk to the court about the things the Second Court of Appeals got correct. This is one of the things that they did get correct, which was the second order. There was 2 summary judgments. There was one that my client 7B filed, and I believe all the other parties joined. There was a trial amendment on the last day of the statute of limitation, or of the scheduling order, that said this is where we get the injunctive relief claim for the first time. It was on March 10th, 2023. So knowing the jurisprudence of the state of Texas, where you want to file a summary judgment that adequately covers all pleaded or non-pleaded causes of action, and you want to make sure you're trying to cover all of them, my client filed a second summary judgment in response to an attempt to defeat the summary judgment through amendment. Everybody joined that one too. So there was a summary judgment order that was signed on the 14th of April. The next one is signed on the 17th of April, 2023. That one contained the decretal language. Anything the trial court did after that, it interferes with it was its own interference with its own final order, and I think it's referenced properly.
A trial court can always ungrant a summary judgment while it has plenary power, so it's not like it's set in stone. But I'm just trying. I've never seen a case like this where a court issues a clarifying order after something with layman finality language in it and says, "Oh, this is just we're just granting a permissive appeal and staying further proceedings." I mean, there weren't any further proceedings, were there?
There were not, and that was kind of the problem with that underlying or with that particular order, was that the trial court did not actually undo or otherwise change any of the finality, the layman finality in the summary judgment order. The order did nothing. It was just we're clarifying, but it didn't actually have any impact at all.
But it seems like it was doing the opposite of clarifying. It was confusing things, but...
We are here now, I think, for that purpose.
And so you say we should just ignore that clarifying order?
I think that it had no effect on the actual finality language in layman, and we can date the limitations period to that, and I do believe the Second Court of Appeals got that part correct. Okay. And I would also point out to the court that that wasn't an issue that was appealed by the respondent party.
Well, but it's jurisdiction, so we got to look at it.
You have to examine it, but I think that the court does have jurisdiction. I believe the Second Court got that correct.
So if you prevail in this case, I mean, isn't this neighbor just stuck with, flooding for the property forever? And they really, I think, from what my reading, were pretty diligent in trying to work with the city in terms of getting something done, early on, right?
I will answer that as plainly as can be. I think that we routinely dismiss cases where there are possibilities of future damages that could be awarded, and the courts say, sorry, you waited too long to bring your claim.
Damage is a little different than injunctive relief.
That's exactly why we're here today. And I think that the answer is they waited too long. And I think that you've got like the River Centers versus Rivera
But
case.
I don't think they did. I mean, they didn't wait in terms of working with the city and trying to figure this out. And we don't want to encourage parties to just file a lawsuit immediately. We want them to try to work through things and try to get things done without the courts, right?
Well, I would say that the city has certain powers that it has not chosen at this point in time to invoke as against my clients, whereas the right of a private nuisance belongs to the party. You can't transfer it to the city, and you can't toll it by having the cities come in or do something or make a request to the city, because the city, as everyone here knows, is not the court system, and the court system's jurisdiction has to be invoked within the periods of time set forth by the legislature.
So there are a couple of different periods of time that are relevant here. One is the 2-year statutory limitations period for trespass that injures property of another, and that's what you rely on.
That is, Your Honor.
But there's also a 10-year statutory period to adversely possess a prescriptive easement to flood somebody else's property.
That is true.
And so why wouldn't applying the 2-year period here basically give you adverse possession without having to wait 10 years?
I think that's the real question we're all here to answer today. That was the first time the court implicated that question was in Rhodes versus Whitehead.
Right.
Now,
In 1863, and
In
we said the
1863.
right to a nuisance cannot be acquired by prescription, and if damming water works hurt, inconvenience, or damage, it's a nuisance of which the property owner may complain. And it seems to me the reason for that is because you've got to accommodate the 2-year statute and the 10-year statute. And yes, you may not be able to get damages after 2 years for a trespass, but you've got to have a way to throw somebody off your land or prevent them from sending stuff onto your land. Otherwise, until 10 years, otherwise you're just going to get adverse possession.
well, I think that we have to take a look at what limitations period was actually at issue in the Rhodes versus Whitehead case. It was one of those things that evaded me until like very recently, and what I reached the conclusion was that the defense did not raise the 2-year statute of limitations period because the original dam that was erected for purposes of the lawsuit in Rhodes was erected on May 1st, 1858, and the plaintiff filed suit against that nuisance, the construction of the dam and the pooling of the water, on August 30th, 1858. So the court at the time did not have the 2-year statute of limitations before you, and I provided an exhibit from the Gamble book to all of you. This is the law as it was passed when we were still the Republic of Texas, and it has always been a 2-year statute of limitations period.
But it's also always been a 10-year adverse possession period. I bet if we went and looked at Gamble's, we'd find that. I'll double check it. But
I'll tell you right now where it is, Your Honor. It is at Section 14, where they talk about the 10-year AP statute. And I would argue that this is where you get the policy balancing of the legislature. You have the legislature saying, okay, we've got injury to land, we've got injury to persons. We want those types of lawsuits disposed in 2 years. It implicates a different policy concern than prescription or adverse possession, I guess as we call it today, which is about the right and the use of land and the ability to sell a parcel of land and a piece of land.
well, I don't understand that though, because I mean, so if they had gone to sell this property, they could file an action in trespass to try title 8 years later and say, we're gonna, your floodwaters are trespassing on our property, and we want to abate that, and because we're about to sell the property, we have 10 years to do that, and that'd be okay?
I don't think so, Your Honor. I think that when, in any other equitable context, the limitations period cuts off the right at equity.
Well, that's under City of Ennis, which was following Rhodes, decided in 1903. The Court of Appeals in a writ refuse case says a claim for damages might be barred by limitations without impairing a landowner's right to abate the nuisance. It cannot be seriously claimed that a neighbor who creates flooding on an owner's land could acquire any right in that owner's realty by easement or otherwise by adverse use that had existed for less than 10 years. So it seems like what the court is doing in that case is giving effect to both statutes. The 2-year statute cuts off any right of damages, but the 10-year statute, up until that expires, you have a right to abate the trespass by the floodwaters.
Well, I would say go
and
back.
it seems like that's what they're asking for in this case.
I would go back to Rhodes for a moment, because Rhodes spent a great deal of time talking about the prior owner's land usage, and it goes back into the Spanish land grant period, and then it goes into the Republic of Texas, whether, reviving Spanish land grants, and then it goes into the, during the Civil War period of time. And what they were asking for was, they wanted an expansion of the common law understanding of prescriptive right. The prescriptive right gives you the use of water the same as everybody else around you. What they were arguing was that, well, we had more rights, and we had the right to injure our friend's land, our neighbor's land, under the Spanish land grant. And the Rhodes case said, this is a rule that we use to establish, it's a legal fiction. It's not the actual land grant itself. And if you don't have evidence of that, the legal fiction cannot be used to extend the right to injure or harm or otherwise touch a party's land.
Sure, that was the main issue in Rhodes, is whether this was a trespass or not, right? Or whether they had a property right to have the water flow over their neighbor's land to begin with. But here there's no dispute. You didn't have that right to have the water, assuming that I understand you may contest that there's any water flowing, but it's taking the allegations as true at this stage that there's water flowing over. Nobody disputes you didn't have that right. So the way that you establish that is by open and notorious flooding of their property for 10 years, and then they can't oust you anymore.
Well, and I would say that part of the case law doesn't need to be disturbed. I mean, I guess that's the thing, is that we're not talking about... But it becomes
irrelevant if it's barred at 2 years. You're basically rendering the 10-year period a nullity.
I think that you've got different policy concerns at issue there, like I said. I think that we're talking about injury. We're talking about making somebody come in and fix the issue at their own expense, or through their award of damages.
That's what Latches is for. Latches accommodates all of those same concerns, and we have a case that says Latches applies in this context of exactly what we're talking about here, where you've got an injunction to abate the nuisance. Yes, 10 years may not have passed, but Latches can still apply. So why shouldn't we look at this as a Latches issue instead of a limitations issue?
Because this court in 1943 made the determination that when you've got courts at equity and courts at law vested in the same court system, that limitations applies equally both to to an equitable cause of action, an equitable remedy, a legal cause of action, and a legal remedy.
Well, except that there's a statute that says injunctive relief is available for irreparable injury to real property irrespective of any remedy at law.
May I finish my point, because it dovetails into this point, Justice Busby? All right. This is what the court said in 1943. However, it might be conceivable that the circumstances of a given case might be so extraordinary that to deny a defendant the defense of Latches would work a grave injustice. In that situation, it's been held that such defense may not be precluded even though the statutory period has not run. That is the Culver versus Pickens case. So the court in 1943 is setting the bounds of Latches. You can use it to truncate a limitations period, but you shouldn't have to use it after the limitations period has expired. It's an equitable remedy where the circumstances are so extraordinary, we can't wait for the period of time to run. We need to take action now. Well,
we decided that as far back as the DeGroff case, which was a lot earlier than that. And I understand your point about Latches for sure, and I agree with it.
Well, and that follows then to the next question, is that in Town of Palm Valley versus Johnson took up the issue of whether Section 65 or Chapter 65 of the Civil Practice and Remedies Code augmented or changed any of the common law equitable requirements to obtain relief under the statute. And they took up, namely, a plaintiff has to demonstrate success. There has to be an imminency that needs to be cured through an injunction. And it itself was using an analogy to another one of the injunctive issues from the first time that the court fixed that issue with a predecessor statute. And the court has routinely concluded, no, the statute does not override the equitable concerns at all. You have to follow the common law rules of equity in order to obtain equitable relief.
We talked about that most recently in the Wynn case, but one of the elements is for an injunction is a wrongful act. That's what we said in Wynn. That's what we said in Pike. why is this not a wrongful act? I understand your point about it's barred by limitations, but limitations is an affirmative defense. It's not an element of the cause of action. So you can prove your cause of action, and then you come in and say, the point of limitations is to say, you may be right that you have a cause of action, but I don't have to pay you because the 2 years has run, or you don't get a remedy because the 2 years has run. But it seems like you still have a cause of action.
I think you can have a cause of action, but the cause of action gets defeated. What's really at issue is, do you still have to prove your cause of action to get your injunctive relief? And you do.
And what we've said is you have to prove a wrongful act. So what does that mean?
I think that wrongful act, and my time's expired, but if I can finish answering the question, Justice. Wrongful act goes back to the cross-text case, and you have to look, the cross-text case requires that you're not entitled to any relief without proving a cause of action. Over here with injunctive remedy, the first element is prove a wrongful act. If you put Hune versus Blanchard and cross-text on top of each other, what they're saying is, you got to come in here and establish all of your viable elements, your liability elements, your duty, your breach, your causation. But then here's the kicker. This goes back to the Schneider case. Even if you can prove all of those, you still lose if you bring the suit outside of time. And the Schneider case, may I make this last point and then I will sit down?
Okay.
Okay, thank you, Justice Blacklock. The Schneider case says this: the distinction between temporary and permanent nuisance has long been affiliated in most jurisdictions with three consequences: the proper measure of damages, the proper member suits, and the proper time for bringing them. Abatement, or junction, may have an effect on damages or it may not, but it should not and cannot have an effect on the other two. And that's what's at issue here today. The respondent party and the Second Court of Appeals are saying, we really think the availability of the injunctive remedy should have an effect on when you can bring the suit. With that, I pass.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Wirt will present argument for the respondent.
May it please the court. Property rights are valued in Texas, and they always have been. And protection of property rights is in line with Texas values. The petitioners now ask this court to do something really extraordinary. They're asking this court to weaken property rights. The issue in this case is really quite simple, and it's the question of whether or not limitations can bar a request to abate a nuisance. And for more than 160 years, the answer in the state of Texas has been clearly no. In 1863, this court decided Rhodes versus Whitehead and said plainly that the right to maintain a nuisance cannot be acquired by prescription. And then in 1895, the International and GNN Railway case versus Davis, the court held that limitations is not a defense to a request for an injunction to abate a nuisance. Interesting to point out that the nuisance in the Rhodes case, which was a dam, had been in place for over 100 years.
So in terms of this idea of not acquiring a nuisance or not acquiring an easement by prescription by a continuing nuisance, is that something different than injunctive relief for trespass, in that even if, say, the landowner herself wanted to abate the nuisance, the property owner that's creating the nuisance could say, oh no, I have a prescriptive right, I have an easement right to divert water this way. So it seems as though there are two different rights: the prescriptive right granted via an easement, which would entitle you to some kind of enforcement, versus injunctive relief to abate a chronic but remitting nuisance. And I'm grappling with why those two concepts are exactly the same. I think they're different.
I don't think the concepts are the same.
Okay.
I think there is a difference between an easement and a nuisance. A nuisance is a wrongful act.
But nuisance, a prescriptive right indicates you've got some right to use the land according to the use you've used it for the last 10 years, and presumably some right to enforce that. And that seems different than what we have here.
Right. I do believe that there is the possibility of having a drainage easement. But that's different than having flooding that occurs across someone's property that causes soot, silt, and mud, and those type of things to come over to where the offended landowner is having to clean it up or is constantly having to deal with it. A drainage easement would be different because that would be the controlled flow of water across the land. So I do believe that you could obtain an easement by prescription. However, I don't believe you can obtain a nuisance by prescription.
Well, a nuisance isn't a cause of action, we've said. It's either trespass or negligence. It's a type of injury to land, and the wrongful act that goes along with that is either intentional if it's a trespass or negligent if it's in the case of negligence. But I guess I'm not seeing the difference between, and maybe you can address it from your client's perspective. Would it be different from your client's perspective if you're suing to stop the flow of water and one rule is the statute of limitations bars you from stopping it after 2 years. That's their argument. But a prescriptive easement, if they had flooded your land for 10 years and you didn't do anything to stop it, it seems like you would, from your client's perspective, you would end up in the same place. Either way, you couldn't get an injunction in one case because of the statute of limitations and in the other case because of adverse possession. But either way, you can't stop the water, right?
I do believe that we could, well, it's an interesting distinction to make. And again,
I'm just wondering if it is a distinction. I mean, in either case, your land keeps getting flooded and you can't stop it.
Yes, correct. The land keeps getting flooded. And I would go back to how I answered the question previously, and that is, I do believe you can have an easement by prescription, but not a nuisance. And an easement, if they wanted to come in and argue that they had a prescriptive easement to come across our land for drainage, that's different than allowing them to come in and argue that they've obtained a nuisance by prescription.
Well, it seems like it's you win either way because it hasn't been 10 years. So whether it's right, I mean, this didn't start more than 10 years ago.
I understand, and if the court says I'm winning either way, then I'll agree.
If you can never do it if it's a nuisance, but you can do it after 10 years if it's a trespass, it seems like it hasn't been 10 years, so.
Right. Either way, I think my client would have the right to come into court and seek redress from the court in our current situation. Interestingly enough, they rely upon the Culver case. The Culver case was not a nuisance case. The Culver case was a case that dealt with fraudulent conveyance, and that property was conveyed one time. And so it doesn't go to nuisance at all. Interestingly enough, I think that when you talk about an underlying cause of action when it comes to an injunction, that I think we can all agree that's kind of been the general rule, that in order to get an injunction, there has to be an underlying cause of action. However, this area of nuisance carves out an exception, and it has been carved out since the late 1800s.
What about the argument that if you would have, say, filed and there was no limitations period for damages and you got damages, the theory is that you would use those damages to construct whatever you needed to construct in order to prevent the flooding?
Well, a couple of things. One, an injunction is a court order, and the cost of complying with the court order is not damages.
But what I'm saying
It's
is
merely
that,
requiring the other party to do what the court orders.
But if you got that money, those damages, then you were able to use that money to prevent the flooding, then you wouldn't need an injunction.
That's correct. I mean, that's a
argument.
correct statement, but damages go to repair an injury. They don't go to necessarily correct the wrong. And that's what we're asking for here. In this situation, this defendant and these defendants contracted with the city of Fort Worth. They entered into an agreement with the city of Fort Worth to construct a drainage system, included I don't want to say it's elaborate, but it was an engineered system that involved concrete with stops along the way that would slow the flow of water. It involved a concrete weir, which hopefully no one asked me to define what a weir is, but essentially it was this elaborate drainage system that they just didn't do. And as the court correctly pointed out earlier, my client worked with the city for more than 2 years to try to get that resolved. We have not appealed, or we did not ask this court to correct the Fort Worth Court of Appeals with regard to our request for damages. We believe that our property was damaged, but we did not ask this court to correct that part of the opinion.
And
We accept that
you
part of the
haven't
opinion.
challenged also the part about that this is a permanent nuisance, right? The Fort
We
Worth Court of
did
Appeals held that.
challenge that. and-
Well, but not in this.
But not in this court.
So in this court, I just want to see if I understand how the different numbers work. We've got it, it is a permanent nuisance, that's not before us, so we accept that. Permanent nuisance arises. Within 2 years of the permanent nuisance arising, the affected property owner can go to court and get damages or potentially abatement depending on the circumstances. If you miss that, you have, I think, 8 more years to be able to do what you want at your own expense to make sure that you're protecting your land. But then when you get to 10 years, it may be that the tortfeasor that's causing this, presumably benefiting its own property by redistributing things onto yours, can stop you even from, at your own expense, fixing it. Why is that not a pretty simple harmonization of these laws?
Well, a couple of things there. I don't believe that my client would have the right to self-abatement according to the case law. But that's on my client's property. My client's always had that right.
So when adverse possession takes effect, what would be adversely possessed would be the right to use your client's property in a way that your client doesn't like. That constitutes a nuisance to you right now.
We're
not at that phase yet, we're not at that step yet, right?
I believe the current state of the law is that they do not have a right to a nuisance by prescription. Again, that goes back to the easement. versus
What do you think
nuisance.
would be potentially adversely possessed in 10 years?
I'm sorry.
What do you think would be adversely possessed potentially within 10 years?
Well, I don't think you can adversely possess, in this context, in this particular situation, my client's land, because this situation is a nuisance. It's
All right,
not
so
a nuisance.
if you think that the 10-year statute doesn't even apply, that makes it even an easier case. We now have a permanent nuisance, 2 years has passed, there's nothing left to harmonize in the law, you lose.
No, I don't think that's correct, because if you look at the law of nuisance, right?
Not a model of clarity. Not a model of clarity.
Absolutely, not a model of clarity. But it is clear that a nuisance cannot be obtained by prescription. That's been the law since 1863.
So fair enough, but you can't make them do anything after 2 years has passed if it's a permanent nuisance that has accrued in the limitations period, unless you're going to say there's just no more limitations
No,
periods
and
for
I don't
permanent
think
nuisances.
I don't think the Schneider case stood for that. They try to argue that, but the Schneider case didn't even address the issue of an injunction. Justice Brister wrote, clearly stated that they were addressing the running of limitations as to damages claims, and then as to the injunction, that was not a question they reached in that case. And so when you look at Schneider, Schneider only deals with damages. So the 2-year statute of limitations only deals with damages. It doesn't deal with the right to obtain an injunction, to abate the nuisance.
Which is a remedy for the cause of action. So I guess if I disagree with you that there's any real difference for a permanent nuisance about the effect of limitations running, whether you're seeking damages or an injunction, then you would acknowledge, if I know you don't accept that premise, it sounds like, but if you did, if that premise was correct, then you would acknowledge you lose?
If that premise was correct, that 2 years as a permanent
Or a permanent nuisance.
If there was a 2-year limitations as to the injunction, I don't believe that's the
Just a
state of the
2-year
law.
limitation for
if
you to be
that's-
able to go into court about a permanent injunction. So I guess the premise that I'm trying to suggest is, if I'm a judge, we've merged law and equity, after a lot of the cases that you're relying on, interestingly enough, but post, it's now happened. And if I'm a judge and the other side persuades me that this is a permanent nuisance and the lawsuit was brought, whatever you're seeking in the lawsuit was brought more than 2 years after that, if I think, okay, well, then the case is gone before it begins. Limitations defeats your cause of action regardless of remedy. If that premise is right, there's nothing else in this case. That's all I'm really asking.
I think if you were the trial court judge and you made that decision, I think you'd be reversed on appeal.
Okay, well, again, let's just live in my hypothetical world for the moment.
Right.
It's one of the few
Right.
privileges
I
we get
understand
of being
you'd like
up
me to
here.
concede that point.
My hypothetical is that that's the law. If
Yes.
that's the law, I know you don't agree with the law, we can talk about that at greater length, but if that's the law, is there anything else in this case that is different about it? Or if that's the law, do you acknowledge that you lose?
If that was the law, then I would agree.
Okay, now go ahead and say what you want about why that's not the law.
Well, I don't agree that that is the law. I've addressed the Schneider case. I briefly want to address the Crosstex case because, interestingly enough, they cite the Crosstex case, again, for the idea that injunction is not available because of that there requires an underlying cause of action. The interesting thing about Crosstex, which I believe Justice Lehrman and Justice Devine were actually on the court for that and involved in the majority opinion. The Crosstex case actually said that nuisance is not a cause of action or a defendant's conduct. Rather, this is interesting, it says, rather, it is a type of legal injury involving interference with the use and enjoyment of real property. So as to the idea that an injunction, again, you mentioned earlier, Justice Busby, the idea of the wrongful act, right? Wrongful act, and that's a very important distinction
So
in
the
this
wrongful
situation.
act can be, going along with what you were saying in Crosstex, the wrongful act could be a trespass if it's intentional. It could be a negligent nuisance if it's not intentional that they're flooding your property, but just negligent. Which is it? Or do you I'll have to go back and look at your petition, but did you plead both trespass and negligence?
We pled trespass
Right.
and negligence.
Okay, I thought
yes.
so.
Yes. But interestingly enough, then, if we say that nuisance is not a cause of action, then the traditional rule that we talked about earlier about an injunction requiring an underlying cause of action just simply doesn't apply when you talk about nuisance.
Well, it does if it's a trespass or negligence.
Well, nuisance in and of itself then has a statute of limitations of 2 years, right? But nuisance is not a cause of action. And so there's this logic, again, that, clear as
Not a
mud,
model
right?
of clarity, as Justice Young said, yeah. The law is not a model of clarity on this issue.
Exactly.
How does this all work if there are different owners? So, for example, in this case, if, the property was under drought conditions and during the drought conditions, a subsequent owner purchased your client's land without knowledge that there was this water flow problem. Is there a
I
new
believe the
running, how does that work in terms of whether these people have any available remedy against the adjoining landowner?
If you follow the reasoning behind Rhodes and the International and GN Railway case, I believe that the subsequent landowner would have the right to bring would have the right to request an abatement of the nuisance. I do not believe that would be barred by limitations.
You don't think it would be baked into the price of the property when it was sold?
It could be.
I let it expire. Oh, doggone it, I missed my time. But I know what, I'll sell it to my pal. Then he can go and get the exact relief that I no longer can get. Does that make any sense to you?
Well, the hypothetical makes sense, yes, but I believe that would be a right that I would have, regardless of whether I sold the property. I mean, if I sold the property, that right that I have to file an action to abate a nuisance, I believe would pass to the subsequent landowner.
And likewise, if the right has expired, then there's nothing to pass on. That's what I would have thought the answer would be.
Correct, yeah.
But if you're a bona fide purchaser without notice of the flooding, what then?
If you're
If you're a bona fide purchaser of the property without notice of the flooding,
I think you're in an even better situation than if you had been put on notice of the flooding. That you would
So
definitely
say you
still
did,
have
the
the
record
ability
was you
to.
did an inspection and it didn't reveal the flooding, and so you bought the property, and then, you know, the next time it rains, you've got a bunch of water on.
Might actually renew a statute of limitations on a permanent or temporary.
Well, it wasn't
use.
your it wasn't the statute of limitations against your claim, because you're a new owner.
Correct.
Luckily,
Like
none of that's really is required.
The
is
flow
it?
of water in an urban environment like this is changing all the time, right? As things are, different properties are developed, you know, new things are built. You imagine a residential neighborhood and the, you know, the water's just going all kinds of different places, and that's changing. A concern would be that your position is, you know, opening things up to just like permanent. If you conceptualize the flow of water from somebody else's property to mine as a permanent nuisance, that I can make them abate at any time in the future,
Well,
you're not really accounting for
believe
the
there had-
reality that the water just flows in different ways all the time, and it changes, and if you sort of let it flow a certain direction for a while, then that's just the way the world is.
We're not talking about the natural flow of water. We're talking about the flow of water that has been diverted through the wrongful act of another person, or through even a lawful act of another person. If it's diverted and it causes my property to flood, that's at section 11.086 of the code.
And certainly you have that claim, but my point is, because the flow of water is changing all the time depending on the way things are built in an urban environment, don't we need some cutoff point where you can't claim 20 years later that, golly, you shouldn't have built that because now it's flowing over here, and lots of other things have been built, and who knows how it would flow, and doesn't it make sense to have a cutoff point and say, okay, after 2 years or after whatever it is, this is just the way water flows around here now, and you know, you got to deal with it.
I don't think so, because, again, I don't think that's in line with the reasoning behind the cases, that you can obtain an easement by prescription, but you cannot obtain a nuisance by prescription. And this particular case, if you want, I see my time has expired, if I could finish. But in this particular case, the nuisance is flooding. It's not drainage that is controlled across my client's property. It's flooding. And so there is damage that's caused. And so, you know, to finish things up, my client is no longer asking for monetary damage. They're just asking for the nuisance to stop, right? And in your situation, you, I believe, are talking more about an easement dealing with drainage that would have to be designed and taken care of while property is developed and built. This situation here, we had a situation where there was an engineered system to deal with drainage. They didn't put it in. She sought help from the city. They didn't help. So now she looked to the court for help to stop the nuisance. And that's what the law allows, and that's why we're asking this court to deny the petition.
Whose decision was it not to complete that system?
I'm not sure exactly whose decision it was, but it would have been, a construction decision. I'm not sure exactly who. I don't know that
Not a
that's something we
landowner
discussed
decision?
in discovery.
And has the city taken the position that it's fine for them to not have built the weir as was initially required?
That's not an official position, but their inaction speaks volumes.
Any further questions?
I forgot to ask you about the jurisdiction question that I asked your friend on the other side. So if there's this clarifying order that grants permission to appeal and stays further proceedings, do you agree with your friend on the other side, we should just disregard this and that and treat it as an appeal from a final judgment?
We submitted competing clarifying orders. The one that I submitted, I believe, would have clarified that the limitations as to the injunction was not a part of the court's order. She signed the other side's order, which I believe did make it a final judgment.
Okay. Thank you.
Thank you, Mr. Wirt. Mr. Downey, you have 5 minutes.
Thank you, Chief Justice. Justice Bland, you asked a question about whether or not a limitation or a nuisance continues into the ownership of a subsequent owner. I will read directly from Exxon Corp versus Emerald Oil and Gas Company. It says the Supreme Court has recognized that a claim for injury to real property accrues when the injury is committed. from Van, so this goes on. The right to sue is a personal right that belongs to the person who owns the property at the time of the injury. And the right to sue does not pass to a subsequent purchaser unless there's an express assignment of the cause of action included. I think that case law and that understanding dovetails with the whole concept of permanent injury, because you would know, hey, this has been going on. I have to put this on a seller disclosure. It means I have to take a reduction in the price of my property. It's the kind of thing that would motivate one to get to court to stop it early. But
if you don't put it on the seller disclosure, your position is still that the purchaser, if they don't know, they did everything they could say, and they don't know anything about it, and they come and then the next big rain, they're flooded out. You would say, unless the right transferred with the sale, no cause of action.
I mean, that is where the case law takes us. And that is exactly what the case law says.
Did the city require someone on your side of the V to build the weir?
For purposes of this appeal, I would put to the court that the wrongful act complained of is that we were supposed to build one and that we negligently did not include one, according to the cause of the plaintiff's petition and the allegations contained therein. I really can't answer whether or not the city required that, only that the city hasn't made an effort to force compliance later on. What I would tell the court, though, is that one of the most important things and functions that a legislature has is to set an outer bound for when a lawsuit can be brought before the courts because of the nature of judgments. And the court itself has opined in the SV versus RV case that limitation statutes afford plaintiffs what the legislature deems a reasonable time to present their claims and protect defendants and courts from having to deal with cases in which the search for truth may be seriously impaired by the loss of evidence, whether by death or disappearance of witnesses, fading memories, disappearance of documents, or otherwise. The purpose of a statute of limitations is to establish a point of repose and terminate stale claims. So I would ask the court this, and it's the question I've been racking my brain over. If we set a statute of limitations that's a 2-year period because we believe all of those concerns are present after the 2-year period expires, what about the remedy of injunctive relief somehow revives all of these stale issues and stale evidence and loss of memory and all of the things that would go with and otherwise preclude a suit for damages? What is it about injunction that's somehow different and implicates a different policy concern that would warrant keeping in place case law that I believe the Schneider court has seriously displaced?
Seems like all the same concerns would apply to a 10-year period of adverse possession. That's even longer, and people might forget stuff, but the legislature said that's how long it has to be.
Well, and I would agree with that, and I think that's the problem. You've got these two competing, overlapping statutes of limitations where the point of the court, why, and this is the thing, why is injury for damages somehow of a lesser concern than injury for damage to land when the issue is all of this evidence will go stale and we will lose the ability to use this evidence in 2 years. But somehow, if you ask for the right remedy, none of those concerns are present. And then that's what the Second Court of Appeals essentially said. And I have to ask, or I guess point out to the court, that Schneider had the best line in Schneider, to me, was the one, I mean, obviously on my side of the aisle, but they go through kind of a review, a summary review of all of the cases of Texas law where the Texas Supreme Court had decided a nuisance one way and decided it a different way later on when it's the same nuisance. And the court goes, assuming each of these cases turned on the facts stated in each opinion, half of them must be wrong. They are simply unreconcilable. But because the Texas test has no standard of reference, it's not immediately apparent which. You can't say something like that in a holding from this court and then not expect it to have far-reaching consequences down the chain onto all of the intermediate court of appeals decisions that have relied on this court. You 9 give guidance to all the intermediate courts, and right here, Justice Brister goes, hey, we were wrong 50% of the time for the last 100 years. That's where Schneider displaced the law. That's where Schneider...
Well, except that Schneider says specifically they're not reaching the question that we're addressing here.
They left it for us to reach it today. And I agree with that, but they gave us a guidepost by saying abatability should not impact or otherwise affect when you bring this lawsuit. And I think you can infer a lot from that. It's just that the lawsuit at the time that was filed before them in that case was It's quasi-class action. It was a whole ton of different people that lived down by the Houston shipping channel, and all they were seeking was monetary damages. With that, if there's no further questions, Your Honor, I appreciate your time for bringing me down here.
Any further questions? Thank you, Mr. Downey. Thank you to all counsel. The case is submitted, and the court will take another brief recess.
All rise.